You already own the gun that could get you arrested this July. Not a black market weapon, not something stolen. Something you paid for legally. Something sitting in your safe right now. Something you have touched 100 times without a second thought. And it is not the gun that is the problem. It is what you added, where you took it, what state you crossed into, what magazine you loaded, what part you bolted on 3 years ago and forgot about. The law did not wait for you to keep up. After the Supreme Court shattered the old map and left states to rewrite the rules themselves, 8 categories of firearms and setups are catching ordinary, law-abiding owners completely off guard. Here is what they are. The first is the modern AR-style rifle. And I'm not talking about every rifle with a certain look. I'm talking about the rifles that, depending on state definitions, can fall under assault weapon bans because of feature tests, detachable magazines, barrel characteristics, or model-specific lists. In states like Illinois and Washington, the legal issue is not just, is it a rifle? The question becomes, what kind of rifle, with what features, under what state definition, and whether you are possessing, importing, selling, or transferring it in a way the law allows. That is where gun owners get ambushed by detail. The rifle did not change. The law around it did. The second is the AK-style rifle, or any semi-automatic rifle close enough to be treated the same way under a state statute. This is where people get into trouble because they think the law only targets one famous platform by name. In reality, many state laws cast a much wider net. They do not care what you casually call the firearm at the range. They care how the statute defines it. A rifle that feels ordinary in one state can suddenly become one of the first guns lawyers mention when they talk about banned or regulated configurations in another. And summer travel makes this worse. A rifle that sat untouched in a safe all spring can become a legal problem simply because you moved it across the wrong state line this July. One drive, one stop, one question from an officer. The third category is the gun that comes paired with a magazine your state does not like. And this is where people make a massive, expensive mistake. They focus on the firearm and completely ignore the feeding device. Washington, for example, prohibits the sale, attempted sale, manufacture, and distribution of high-capacity magazines holding more than 10 rounds, while also drawing a specific distinction between those activities and simple possession. That kind of nuance is exactly what gets people burned. They hear one simplified version of the law online, assume they understand it, and never stop to ask whether their road trip, online order, private sale, or move into a new state changed the legal picture. Here is the practical reality. Sometimes the magazine is the first criminal charge, not the gun. The fourth is the .50 caliber rifle, which many gun owners never imagine would become its own legal category until they discover that some states treat it that way on purpose. Illinois specifically regulates .50 caliber rifles under its assault weapon framework. That means this is not a general "be careful with rifle laws" warning. This is one of those categories where the rifle itself may be singled out in ways that surprise people who assumed caliber alone did not put them into a different legal world. People travel, people relocate, people sell, people inherit. And suddenly, a rifle that was once just the big one in the safe becomes the center of a legal issue they never saw coming. The fifth is the unserialized firearm, what most people call a ghost gun. And this category is now one of the most aggressively prosecuted in the country, precisely because it catches two completely different kinds of people in the same net. The first kind is the person who deliberately avoided serialization. The second, and this is the one that matters for this video, is the person who genuinely thought they were just doing a parts project. A hobbyist. Someone who watched a build video 3 years ago, put together a frame, and forgot it was sitting in a drawer. California now requires unique identification for unserialized firearms and prohibits both possession and transfer of any firearm without a serial number or state-recognized mark. It also tightened rules around precursor parts, meaning the frame, the receiver, even certain unfinished components can be the legal problem before you ever attach a barrel. So when someone says it's not even a gun, it's just a frame, That confidence has an expiration date. In several states, that expiration date was 2 years ago. The penalty in California for unlawful possession of an unserialized firearm can reach up to 3 years in state prison. That is not a fine, that is not a warning, that is a felony. The sixth is the home-built or 3D printed gun, especially the one made with equipment a state now regulates more aggressively than the owner realizes. California's recent firearm laws go directly after that space by restricting unserialized builds, requiring licensed manufacturing in certain circumstances, and limiting possession or use of specified manufacturing equipment in ways most casual owners never study until it is too late. The "I built it myself" mindset still sounds harmless to a lot of Americans, but in some states, by this July, the home build angle is not your defense. It is the reason the government is interested in the gun in the first place. The seventh is any semi-automatic pistol or rifle touched by a machine gun conversion device, the so-called switch, chip, or auto-sear. This is one of the most dangerous categories because people talk about these things online like they are edgy accessories. Federal law treats them as something far more serious. ATF classifies these devices as illegal machine guns under federal law. A conversion device by itself can be illegal, even if it is not attached to a pistol or rifle. Read that again. The device alone, uninstalled, in the box, in your drawer, can be enough to destroy your life. The federal penalty for possession of an unregistered machine gun, which is what a switch converts your pistol into under federal law, is up to 10 years in federal prison and a $250,000 fine per device, not per firearm, per device. People have been charged for switches still in the shipping packaging. The device does not need to be installed. It does not need to have been fired. Possession alone in many federal cases has been enough. This is not a state gray area. This is a federal priority. And it is destroying the lives of people who thought they were just buying a curiosity off the internet. The eighth is the gun that becomes illegal not because of its original form, but because of the attachment, brace, threaded barrel, flash suppressor, stock configuration, or conversion part added to it over time. Illinois, for example, regulates not only certain firearms, but also, quote, assault weapon attachments. And its examples include pistol grips, folding or telescoping stocks, flash suppressors, threaded barrels, barrel shrouds, and parts designed to convert or facilitate shoulder firing. That means a person can start with a firearm they think is completely ordinary and slowly accessorize it into a felony, without ever emotionally feeling like they bought a banned gun. They did not buy one, they built one, by accident, over time, one part at a time. What the Supreme Court actually did and did not do. Here is what Bruen actually did and did not do. The court struck down New York's discretionary carry system, the one where officials could deny a permit simply because they personally decided you did not have a good enough reason to carry. That system was gone. And gun owners across the country heard that ruling and exhaled. But the court did not ban licensing. It did not strike down feature-based restrictions. It did not tell California to remove rifles from its assault weapon list. It did not tell Illinois that its attachment regulations were unconstitutional. It set a new legal test that regulations must be grounded in the historical tradition of American firearms law, and then handed that test to 50 different state court systems to interpret 50 different ways. That is not simplification. That is 50 new arguments happening simultaneously. And while those arguments are still being fought inside courtrooms, you are driving your rifle across a state line this July, assuming someone already won. Nobody has won yet. The map is still being drawn. Here is what is coming next. If this is the kind of legal breakdown you want before you travel, sell, modify, or inherit a firearm, subscribe right now. Because the next video in this series covers carry laws specifically. Which states still honor your permit? Which ones changed their reciprocity rules post-Bruen? and which ones will treat your out-of-state license as meaningless the moment you cross their border. That video goes out this week. Subscribe so you do not miss it. The most expensive gun mistake you can make this July is assuming the legal question starts and ends with whether you bought the firearm lawfully once. In many states, that is not the end of the analysis anymore. The platform matters, the features matter, the magazine matters, the attachment matters, the serial number matters, the conversion device matters, the state line matters. And after the Supreme Court fallout of the last few years, the owners who get into trouble are often not the ones trying to act like criminals. They are the ones acting like the law stayed simple when it didn't.